Thank you for joining the webinar. Today we're going to talk about the Rape Survivor Child Custody Act here in Iowa. Our presentation is titled, What a Survivor Needs to Know. So Iowa has now adopted a Rape Survivor Child Custody Act passed in 2016. This has foundational roots in federal legislation that was passed as part of the Justice for Victims of Trafficking Act in May of 2015. Title IV of that act was the Rape Survivor Child Custody Act. And essentially what it did was direct the U.S. Attorney General to be able to make monetary grants to states that passed qualifying legislation or laws that would help rape survivors who had become pregnant and then chose to either parent that child or put that child up for adoption, and so create the possibility that the mother in that circumstance could petition the court for the termination of her rapist's parental rights. So essentially the federal legislation says if you pass these qualifying laws, states, we will increase your STOP formula grant funding, and you can be eligible for up to 2 years. In order to qualify, the legislation passed in each state had to, one, permit the mother to terminate parental rights of her rapist, as discussed, and two, could not require a conviction as a necessity for her to be able to terminate parental rights of her rapist. And three, essentially stated that the court must utilize a clear and convincing burden of proof or standard when reviewing these cases. Prior to this legislation, only 6 states had statutes terminating parental rights of rapists on clear and convincing evidence. Now there's approximately 45 states since this Rape Survivor Child Custody Act legislation incentivizing qualifying laws has passed that have taken such steps, Iowa being one of them. So among adult women, an estimated 32,101 pregnancies result from rape each year. This is according to the American Journal of Obstetrics and Gynecology. So that just reiterates that survivors are not alone. There are many women that have suffered similar circumstances in which there's been further trauma to them, not only from essentially their sexual assault, but the pregnancy that resulted from that assault. So Congress recognized that a rapist's ability to pursue parental or custody rights forced the survivor to have traumatic psychological effects and made it difficult for her to recover. So essentially, on its face, it does not seem fair that she should have to be further traumatized by her sexual assault by having to co-parent with someone for approximately 18 years. And she should be able to focus on her ability to raise a healthy child free from those additional stressors. So that's where we get the Rape Survivor Child Custody Act. Essentially, Congress said, okay, here's the number of women approximately each year that their rapes result in pregnancy. We also know that, according to one study, 32.3% of women who were raped become pregnant as a result of the rape and keep their child, so almost a third. And then we know that 73% of women who became pregnant as a result of rape carried their pregnancies to term. And 64% of those women chose to raise their child. Again, rape, sexual violence generally is the most under-prosecuted serious crime in this country. occurring prosecution and criminal conviction occurs in less than 5% of rapes. We also know that sexual violence is heavily underreported, period, regardless of criminal conviction outcomes. So what can we do for survivors that are facing these circumstances? You start by reaffirming to survivors, again, they're not alone in this circumstance. What happened was not their fault, and they're not alone. That they can decide how and when they talk about their assault. And then we want to encourage them here in Iowa that there is free and confidential support available. Please refer to Iowa CASA's website and connect a survivor to a local member program where they can receive a confidential sexual assault advocate to essentially be there to help be by their side throughout this whole process and determine what options they're eligible for or would like to pursue. So the Rape Survivor Child Custody Act here in Iowa was added to Iowa Code in 2016. Again, the federal legislation says if you pass the qualifying law, you get an incentive of STOP funds, grant funds to your state. And so Iowa was subsequently awarded $26,913 as a result of passing qualifying legislation to meet with the federal standards of the Rape Survivor Child Custody Act. And again, those standards were it had to utilize clear and convincing evidence as the burden of proof. There could not be a requirement for of a conviction to have termination of parental rights. And essentially the court had to set up, or the legislature had to set up a mechanism so that a mother could terminate the parental rights of her rapist or petition to terminate the parental rights of her rapist. So here's the act itself that was passed here in Iowa. Now you'll notice I specifically stated the federal legislation required a mother to be able to terminate the parental rights of a rapist. When we look at the act and legislation and subsequent code sections added here in Iowa, we see that it's gender neutral. So it says the biological parent against whom the sexual abuse was perpetrated, rather than mother specifically, can request termination of the parental rights of the biological parent who terminated the perpetrated the sexual abuse. You'll also notice that the legislature added the code section, or two code sections to Iowa Code, one being found in section 232.116, the other being found in 600A.8, and we will discuss the differences between those code sections in just a moment. So again, the Rape Survivor Child Custody Act provisions were added to both two code sections, one being the involuntary termination of parental rights section, and the second being the voluntary termination of parental rights code section. 232.116 essentially is the involuntary code section. This is the code section utilized by county attorneys, DHS. It's the Human Services section of the Iowa Code. The other code section, 600A.8, that is the voluntary termination code section, where essentially a parent or guardian can ask that the another parent's or biological parent's rights be terminated, rather than having to have a mechanism going where there's investigation or DHS has found a founded complaint and then subsequently needs to open up a child in need of assistance case. This is a mechanism or means in which a parent can voluntarily just come to the court and say, I'm requesting this action happen. So we saw the act earlier. Let's take a closer look at the code section, particularly the voluntary termination of parental rights code section, that is Iowa Code 600A.8. The reason we're focusing on this is because it's most likely that this will be the avenue that survivors seeking advocate services or coming to Iowa Legal Aid or private attorney, this is going to be the mechanism that they'll use to petition the court. And that new subsection states, the court finds there is clear and convincing evidence that the child was conceived as a result of sexual abuse as defined in the section 709.1, and the biological parent against whom the sexual abuse was perpetrated requests termination of the parental rights of the biological parent who perpetrated the sexual abuse. And essentially this code section is the grounds of, when we say grounds, the reasoning that the petitioner or survivor in this case is coming to the court to say, these are my grounds, this is my reasoning for seeking termination of parental rights. Taking a closer look at section 709.1, which defines sexual abuse, we see that it's any sex act between persons when the act is performed in essentially, we have to meet one of three requirements: done against the force or against the will of another, without their consent, can also include actions done under the influence of drugs or unconsciousness. So essentially, if the person is incapacitated in a way that they cannot consent, or the act is done against their will or force, then it would meet the requirement here. And then another option, or two, is that if the person is suffering from a mental defect or incapacity which precludes them from giving consent. So if they're mentally incapable of making self-determinations or consenting, they can't consent to sexual intercourse, and that could be potentially sexual abuse as defined by 709.1. A third being the person is a child. Child cannot consent. The age of consent here in Iowa is 16. So what does termination of parental rights mean? We keep saying to the ability for a parent to terminate another biological parent's parental rights. What exactly does that mean? When a parent's rights are terminated, it means that they have no legal claim to the child in the eyes of the law. No legal rights. You can't have contact with the child without a legal guardian's consent. You cannot have a say as to where the child lives or make determinations about his or her upbringing, including education, religion, etc. The parent whose rights are terminated becomes essentially a legal stranger to the child. So who can terminate parental rights? When we talk about this process, we're saying that the biological parent will petition the court. When we say petition the court, we essentially mean a judge. A judge will hear these cases, hear testimony by the survivor and any evidence, and only a judge can make a determination to parental rights. Again, this is kind of going back to the fact that the Rape Survivor Child Custody Act passed here in Iowa added two sections to Iowa Code, one being bound in the Health and Human Services section of Iowa Code, which is a county attorney can ask for the parental rights to be terminated in a child in need of assistance case. DHS can bring actions to terminate parental rights. However, most survivors that will want to seek this as a remedy will utilize, again, the 600A.8 section, which controls voluntary termination. And so they'll essentially petition the court and ask that the rights of the rapist be terminated by the judge. So we talked about essentially to have qualifying legislation, the burden of proof for these cases had to be clear and convincing evidentiary standard. And so what does clear and convincing actually mean? Clear and convincing, first and foremost, is the burden of proof that's used generally by in termination of parental rights cases across the board. And so the Rape Survivor Child Custody Act developed that same burden of proof or evidence standard as a requirement for these cases. So what is clear and convincing evidence? What does that standard mean? There are essentially three primary burdens of proof. One we see frequently in criminal cases. If you've watched any episodes of Law and Order, you know beyond a reasonable doubt. We think about that. We think about defense attorneys of the world that are just trying to place some doubt in the minds of a judge or a jury, and then they can have essentially a not guilty verdict or an acquittal for their client. So that's the highest, if you think about it, the highest level or burden of proof, the most difficult to reach. And then also there is a burden of proof called preponderance of the evidence, which is at the bottom and utilized in civil cases. We frequently say that this is 50% on a feather, or essentially proving that something is more probable than not for having occurred the way the survivor stated. For these Rape Survivor Child Custody Act actions, we're going to look at the burden of proof that is in the middle, which is clear and convincing evidence. And in order to meet clear and convincing burden of proof, the survivor must prove that it is substantially more likely than not that their child was conceived by rape. So we talked about preponderance of the evidence, the lower standard being more likely than not. They add the word essentially substantially, saying even more so that it's more likely than not that the child was conceived by rape. And essentially, I encourage, when talking with advocates and survivors, I encourage them to just kind of think about the words. At what point would a judge be clearly convinced that this happened the way the survivor stated? And that's your burden of proof. It's not easy to put a percentage or some kind of measuring stick at it. It's much more subjective than that. But essentially, what kind of evidence can you provide that would clearly convince a judge that the survivor was a victim of sex abuse under 709, and it resulted in a child, and therefore that in order to protect the survivor and the child's best interests, they need to have the rapist's parental rights terminated. So what may be considered as evidence? These are just a few possibilities. Undergoing a sexual assault forensics exam can be evidence to help meet the burden of proof. Seeking follow-up healthcare services and reporting to a healthcare provider. Reporting to law enforcement. Whether or not charges are filed in these circumstances. Again, we know that many survivors don't choose to go the route of law enforcement, or there are circumstances where they do pursue an investigation with law enforcement, but there's no charges that are filed. Even providing what maybe little or kind of disappointing results there may be through the law enforcement process can be utilized as evidence. in these cases to show the judge that this happened and the child was the result of a rape or sexual abuse. Also to receiving advocacy service from Victim Service Program. If the survivor was in trauma, got connected with a local program, that advocate or local program with the survivor's permission can show the documentation of when they sought services, when they came into their office, what they were seeking services for, etc. So just just a few examples among many of what can be considered as evidence presented to the court. So we talk about how termination of parental rights essentially makes the parent whose rights are terminated a legal stranger to the child. How does that impact child support and public benefits? Essentially, under the federal legislation of the Rape Survivor Child Custody Act, they don't make any suggestions to the states on how to approach this. They don't say, oh, well, you should keep an avenue open for survivors to seek child support, even though there's a termination of parental rights. And so it's up to the states individually. And the way Iowa Code sections and law and the provisions that are established here in Iowa have set things up. Essentially, if there's a termination of parental rights, then there's a termination of child support. So that's something that's very important to discuss with the survivor, knowing that if you're seeking this relief under the Rape Survivor Child Custody Act, there's no special, there's nothing preventing it. So maybe you can try to pursue it through the court. But generally, if a court terminates parental rights of another party, they terminate that other party's child support obligation as well. And there's some constitutional considerations at play there. Should you have to pay for a child that you essentially are a legal stranger from, it's like you were never their parent. So in regards to public benefits, for the most part, the survivor or parent that is seeking the termination of the parental rights still qualifies for most public benefits. So if they're seeking public assistance or that kind of thing, sometimes public assistance will, the public assistance or child support recovery unit will request, can you please name the father in this circumstance, so that the state can try to recoup what support they provide to the child. In that circumstance, providing essentially a court order saying, hey, this party's parental rights were terminated, shouldn't bar them from receiving any kind of public benefit or support. So how can a survivor get relief under the Rape Survivor Child Custody Act? These cases are so new. We talked about the provision just being added to Iowa Code in 2016. There is no case law to date that kind of fleshes out the nuances and details around this the Rape Survivor Child Custody Act actions. So at this point, it's essentially the legislature has acted, but the judicial branch hasn't gotten to weigh in yet. And because of that, and because there's such new actions, I highly recommend that survivors get connected with attorneys. Again, they can certainly self-petition. That was the whole purpose of the Rape Survivor Child Custody Act. The federal legislation was encouraging some kind of mechanism where The mother could self-petition a court to terminate her rapist's parental rights. They can certainly do that. You can refer to a local comprehensive advocacy program for support and resources. But again, advocates cannot give legal advice. So they can be there to go with the survivor to the courthouse, but they can't give legal advice or kind of help draft a petition or something like that. That would have to be another something that the survivor either does themselves or seeks other resources. Those other resources are, of course, Iowa Legal Aid or seeking a private attorney. In actions such as these, the survivor has a right to an attorney throughout the whole proceeding. They don't have the right to a paid attorney throughout the whole proceeding, but Iowa law does state you have a right to counsel throughout the process. Do be aware that while they have the right to counsel throughout the process, if the opposing party or the rapist in the circumstance is found to be indigent or low income, essentially, because these are involving parental rights, which are constitutional rights, he or she or that rapist or biological parent can actually be appointed an attorney by the court system. So that's something to be aware of again too. Again, we want to state that advocates are able to assist victims. There's advocates in various member programs throughout the state, located across the state, in all 99 serving all 99 counties. These advocates can provide trauma-informed assistance with filling out the paperwork. They can provide support throughout the hearing process and follow-up services, counseling, safety planning, whatever the survivor may need in regards to seeking either the assistance of the court through the Rape Survivor Child Custody Act or whatever mechanism they're pursuing through the court to help ensure their safety and recovery. So that's all the time that I have for our presentation today. If you have any questions, please feel free to reach out to me. My email address is attorney@iowacasa.org. Again, these Rape Survivor Child Custody actions are brand new. To my knowledge, we have not had cases with survivors that have gone to court yet. Hopefully that those there starts to be an awareness that this is an option for survivors and something that they can pursue. But if you have any questions or thoughts or just general discussion points, I would love to hear them as these actions start to come or move forward. So thank you for your time and thank you for joining the webinar.